We are live. Welcome back, folks. This is the afternoon meeting of the Joint Justice Oversight Committee, and we're continuing our conversations about juveniles. And we had discussions this morning, justice involved juveniles. We also had discussions about raising the age, and we had discussions about the Beckett proposal for justice involved juveniles. So this afternoon, we're going to start with talking again about juveniles and out-of-state placements and the number of those that are currently out of state, and also the question of the efficiency of sending them out of state, and if it's a policy that we continue. So Commissioner Brown, welcome back.
Sure, thank you. For the record, again, Sean Brown, Commissioner for the Vermont Children and Families. With me today, I have our clinical director, Jennifer Herbert, and then also our general counsel, who is on Zoom, Jennifer Micah. So I might be phoning a friend presentation. Just to level set for the committee, we did prepare a PowerPoint on the after the title page. You will see our current data of number of youth in residential treatment, and that would include Sununu at this time. So you'll see we have it broken up by in-state and out-of-state, and also you'll see by two columns of the type of case type. One is children in need of care supervision, like our child welfare side of the house, and then our juvenile justice side, those adjudicated delinquent. As you can see, the vast majority, probably 80% of our youth in residential care are on the chin side. And so we have 19, for this committee's focus, we have 19 youth in residential placement right now, including the one youth who's at Sununu. Of 19, 5 of those are in-state and 14 of those are out of state. And so we have a total of 119 youth right now in some sort of residential, whether it's state or out of state. That is down from about 4 or 5 from about this time last year. So we're seeing a decline in those numbers, a small decline, but yet a positive development. One of my goals as commissioner is to try to reduce the reliance on residential placements and try to have kids served closer to home in their home community, either biological parents or foster parent receive community-based services. And so that is going to be an ongoing focus of the department in the coming years. In terms of the process that we must go through to place a youth in an out-of-state placement, there's a couple different federal processes that apply. The first is the Interstate Compact of the Placement of Children. You'll hear it referred to as the ICPC. It regulates the placement of all kids outside of a state into another state. That applies to foster care, kinship care, parental care, conditional custody, residential, and adoptive type situations as well. It can include children that might be through the mental health, the Department of Aging and Living, the Agency of Education. This process applies to kids, basically any child in another state's treatment program or a treatment program in another state. You need approval through the ICPC prior to placing that child in another state. I will point out that hospitals and psychiatric facilities are not considered residential placements. So if you're placing a youth in those types, they're exempt from the compact. Youth who are adjudicated delinquent require a court order before they can be placed out of state, and whether that's in Sununu or another type of residential placements, and these youth cannot waive that hearing. It's a hearing that must occur. Children who are not, basically child welfare children can waive their right to a hearing, provided if they're over age 10 and provided their attorney and GA agree to the out-of-state placement. And then there's a process where they can sign a waiver and allow that placement to happen sooner than waiting for a court process. If there is an objection, then a court hearing must be held before, and a court order issued before we can place that child welfare child out of state. The other mechanism where we can place children in another state's treatment program are under the Interstate Compact for Juveniles. And I mentioned this a little bit earlier in my prior testimony today. Refer this as the ICJ. This is essentially when a youth runs away from another state and ends up in our state and certain conditions are met, we can place that youth in another facility pending the return to the home state. And that's a much more straightforward process. And so that really applies to youth who run away from another state or deemed to be a danger to themselves or others, youth who have a warrant in another state. We are required to put them in a secure setting pending their return. And as I indicated, there's not a requirement for court order for a placement of a youth under the ICJ. So if someone that comes, runaway as a runaway from their home state, gets picked up in Vermont, and they have an outstanding warrant or something else happening, we're required to place them in a secure setting. And as I indicated before, we have utilized that process in Vermont for 6 youth who, since Woodside closed, had run away from their home state, ended up in Vermont and met the criteria where we could place them in Sununu pending their return to their home state based on the conditions under the ICJ. Those days tend to be brief as we work with the home state to coordinate a return with the Child Welfare Agency or the Juvenile Justice Agency in the other state. And as I indicated, we have placed 1 youth in Sununu, but as you can see, we've also placed other juvenile justice youth in other lower level residential settings out of state. And in terms of whether there's a delay, given it's a small number of youth that have required a court hearing, particularly on the juvenile justice side, since we've closed Woodside, we've really not experienced any delays in the judicial process. The most recent case from start to finish, from when the youth was picked up until we received an order and we could place that youth out of state, I think it was 6 days. So from my count, so we believe the judiciary has been very responsive in holding hearings on these type of situations where it's important to get a youth connected to treatment services quickly. Judiciary and the Defender General's office have been able to respond very quickly, so the hearings can be held, and we've not really experienced any delays.
We do have a question from Senator Sears. Dick?
Just a clarification, Commissioner. If the child from out of state has committed a crime in Vermont, how do you deal with that then?
Normally, our team works with the local state's attorney's office and their attorney to determine, what's the stance of the prosecutor and how they want to resolve that. And many times, if a youth agrees to return or the other state is willing to pick them up, they're willing to dismiss the charges in Vermont and let the other state take jurisdiction over that youth. That's been our experience.
Thank you.
So when Woodside was up and operating, do you know how many on average we had of out-of-state youth?
I don't know, and that it would take us, given the records are not stored, we would might have to go back and it would take some time.
Just curious.
So I will point out that we would be able to utilize the Beckett facility for these, what we would refer to as ICJ kids, that they would be able to access that program as well, pending a return to their home state. So that would be another, just not Vermont youth would be served there, but youth that are involved in the juvenile justice system at age range from another state would have access to the Beckett program once it opens. And that's how we would utilize it as well.
But not at the expense of pushing out of Vermont.
No, obviously we would. Our goal is always to return kids to their home state as quickly as possible.
Question? Lisa.
Commissioner, in the data on the first table there, out of state child in custody adjudicated delinquent 14. Is adjudicated delinquent same group of people who would be at Beckett?
Could be, yes, could be.
Could be
Yeah.
them, or it could be
Yep.
that
Yeah.
could be a larger group.
these are right now, what we have here are kids adjudicated delinquent that are in some sort of residential treatment, whether out of state. There's a greater number of those who have been adjudicated delinquent, but are receiving in the community.
Right, I see that.
Yeah.
So I guess my question is, more directly is, do we have 14 kids out of state that would have been in Woodside?
They could have been initially. We normally utilize out-of-state programs because the needs of the youth are unique and so specialized that we just don't have the numbers to create programming for that. And so we locate a treatment program in another state. Many of them are located in Massachusetts, New Hampshire, or New York, or surrounding states, but we do access programs. We had one youth that was in a program in Utah, for instance. It was very specialized to their needs, and also in other areas of the country, but those numbers are much smaller. So I can't say that they would be in the Beckett facility because long-term, their needs might be better met by the programming available in this out-of-state placement.
So I guess another way to ask this question comparatively, since Woodside has closed, has that number gone up? What would that number have been, 18 months ago?
Well, the numbers at Woodside had been low for a while.
Yeah.
Historically, Woodside at some point.
But the number of out of state,
Yeah, it's hard to say. I would say, given we've been working with an in-state provider who has enhanced their program to meet some higher level of need, there may be some youth in that in-state number that would have gone to the Beckett program, to be honest with you. If they're in an out-of-state program, it's more likely they need that level of service of that out-of-state program. They might initially start it off in Beckett while we assess their needs, and then they would have transitioned to that program, most likely, just given it that more meets their needs longer term.
And what's the average length of stay in those out-of-state programs?
It can vary. And that's one of the things we're looking at as a department. One of the things I've tasked the new DCF clinical director is to start focusing on youth who are in placements greater than 9 months. Because I think there's research out there that indicates that that you get diminishing returns on your treatment past 9 months. And so we really want to understand our youth who are in-state and out-of-state that have been there longer than 9 months. And so that's something we're just starting to look at as a team, because I really want to understand why those kids are still that long. Our goal is really, as I indicated at the beginning, we really want to get kids back into the community as quickly as possible. That's where their family and friend connections are. And we know that those are some success factors for kids longer term.
The things that, we've seen recently in some of the justice reinvestment stuff in the Department of Corrections is they're really more expanded look at what it takes in order for people to be successful in the community and the supportive services that they're working with other departments to implement. And I'm just curious, I'm presuming, I guess, that you have that same sort of working relationships with other departments for the sort of family support services that might be necessary as well as the individual therapeutic services that might be necessary for the youth. Is that right?
Yes, and so one of the initiatives we've been working on as well, and I think we've given testimony in other committees, we're trying to really create some higher end foster homes who can take higher level of youth without having to put them in some sort of higher level setting and to provide some wraparound services. And so we were recruiting foster homes who were interested that felt like they could do that. Our goal is to get 12, at least one in each district. We've identified 4, and they will receive specialized training and also additional wraparound services from a community provider so that they're able to support that youth. And maybe we can keep youth that might have in the past gone to a residential placement more in a community-like setting connected to their school and their friends and their community. And so that work is going on. We also work very closely and meet regularly with, we have a team that triages youth and seeing, what's the best course of action for that youth that we work with the Department of Mental Health, the Department of Aging, Disabilities, Aging, and Independent Living. We have membership from both of those and DCF that triage kids, what what residential program is best fit. Is there a community setting that might be able to meet the youth, the needs of that youth? And so, we do have that review process and try to see, is it better for one department to take the lead in how this youth is served than the others, even though they might be in DCF's custody, just depending on the needs of that youth.
And you said you've identified 4 of those specialized foster homes. Have they been able to utilize them yet, or are they still in
I
the
think
development
we're
process?
close to being able to launch that initiative very soon. We've identified the foster homes, the training's being provided. We're contracting for those increased wraparound services right now. And so we hope by the end of the summer, we'll be able to roll that out as our goal.
Thank you.
So if a youth, adjudicated youth or delinquent, is in an in-state placement that they are ejected from, then what happens? Are they more likely to go to an out-of-state placement, particularly juveniles in custody that are adjudicated?
I think it depends on their level of need and specialized needs. We do first try to look to see if there's an in-state program that can meet the needs of that youth that is willing to serve that youth. And so that's always our first goal is and this does happen. It happens with chins,
Right.
chins and juvenile kids where, they run away or something happens and the program feels like they can't meet their needs. And so we first look to see if there's another in-state program. If not, then we turn to look to see if there's an out-of-state program. A lot of times we can temporarily meet their needs with another in-state, but long-term it's better for that youth if we connect them with a higher level of programming in another state. And so that does happen.
Do you have, for the in-state contracts that you have, are they no eject? Or is Beckett going to be the only one?
Right now, these are they have the ability to ask someone to leave. Beckett will be the only program for justice involved youth that will be no eject, no reject. Programs when we ask them to serve a youth will evaluate the youth and the needs of the youth to see if they can meet the needs. If they feel they can, we'll place the youth there. If something happens and they ask that youth to leave, we understand the situation and the circumstances. And then if we're not able to bridge that gap, provide additional supports to keep the youth in that program, then we look and see if there's another in-state program that can meet their needs, and then we would then turn to out-of-state.
And if Beckett is full and you have a situation, then you'll look at out-of-state if you don't have any other.
Exactly. And I think that's one of our goals is, to make sure when a youth comes into the Beckett facility to really start looking at developing the transition and the treatment plan immediately. Because again, our overall arching philosophy is to get kids back into the community as quickly as possible, or to a lower level system of care as quickly as possible to meet their ongoing needs.
Question? Dick and then
Yeah.
Trevor.
Actually, looking back to your comments earlier about the new Beckett program, that you were worried that would be taking staff away from other programs in the area because you're paying higher at Beckett. Is that part of the reason that our in-state is lower now, because staffing residential programs is more difficult? I just don't know if there's a connection here.
Yeah.
You mentioned that earlier, and I'm just curious if, I think I just lost your figures, but you had of the justice involved youth, 5 in-state and 14 out-of-state. Would that turn if there was more staff in these programs to care for those kids?
Yeah, it's not tied to the bringing the Beckett on and the wages at the Beckett program, but what we're seeing across providers right now, just not our youth residential, but of many, whether it's our housing partners or other partners, are really having a hard time finding and retaining staff right now. And so staffing has been a limiting factor in the number of beds that we have available in Vermont right now.
Thank you. I mean, that's, I know the committee's aware of it. At our last meeting, we discussed the difficulty of hiring people to work in correctional facilities. Same problem. I mean, maybe we should hear from the Agency of Human Services about the scope of this problem. I don't know if it's just
Trevor?
pay, though. I don't know if it's just pay, Commissioner. I don't.
Yeah, I think there are a lot of dynamics and factors at play there.
Thank you.
Trevor and then Ginny
Yeah.
and then Cheryl.
Yeah, Commissioner, I'm curious when I look at these two categories, and then the in-state, out-of-state. Have you done a comparison on the cost to provide those services in-state versus out-of-state? Because I have experience with the TBI program in the state of Vermont, and where people were going out of state for quite a long time. It was decided that, well, if we bring them in-state, number one, we're getting close to community services. But, oh, by the way, it's half the cost, to do it in-state as opposed to some people else. So that's my question.
Yeah, I think there's multiple factors to consider there, but, we do see sometimes that our out-of-state providers are larger providers. They just serve a larger population. So they're able to do it more cost effective. But also, and some of our in-state providers, based on the type of service they provide, they're smaller programs. And so smaller programs tend to be a little bit more expensive in general, just because of how they're structured in their overhead. So I think that is a factor, but I think, there is what you say. We do see sometimes out of state can be a little more cost effective, but that's not something I look at when we're trying to determine what's in the best interest of kids. It's really what's the program that's available, what are their needs, and how quickly can we get them access to it. Those are the things we really look at.
I would agree with that, but at some point cost is a factor. Yeah, thank you.
Ginny and then Cheryl.
Yeah, thank you very much. This is very helpful. And I know that the Child Oversight Protection Committee will also be looking at this information and related. But I guess I have two questions. One, did we actually pass the Interstate Compact for the placement of children? Have we done that?
Being relatively new in that position, we may need to have that revisited by the legislature. I think, it's an update to it. And I think that's still something that needs to be considered for legislative approval.
So Ginny,
Okay,
I'm gonna jump to Marshall Paul. Could you explain a little bit more, possibly?
Very briefly, the ICPC, there's two versions of the ICPC. And we do have the ICPC has been adopted.
You can't hear, so you've got to come up. Welcome to the world of hybrid. The mics are very sensitive, but they can't pick up the audience.
I apologize, Senator, as I was thinking in person, not electronically. There has been an ICPC in Vermont for quite a long time. There's a new ICPC that I don't recall. I know that House Human Services, I believe, has passed the new ICPC. I don't recall if it's been through the Senate or not, but it doesn't really matter because the way that the interstate compacts work, it wouldn't take effect until a certain number of states had ratified it. Last time I looked at it, it was like 16 states have ratified it and it needs like 30 before it becomes effective. So until that time, we're still relying on the old ICPC, which may be forever. It's possible that they'll never reach that 30 state threshold to trigger the new ICPC.
Thank you.
Thank you. Yeah, I think you're right. I think the bill is in our committee, but I wasn't clear. I wasn't clear that it was an update to current statute. So that's very helpful. Thank you. The other question I have actually is, if we were to break out the services that are being provided for the kids who are the non-delinquents, for example, who are out of state, someone brought up cost, and obviously there's a high cost to the more specialized services, but how many of those children are receiving highly specialized services out of state that we can't provide in state?
So we can do that analysis and have it ready for the child protection hopefully by
Okay.
the time for our testimony later this month, but I think that's work we could have our clinical director take a look at, and we can hopefully be prepared to provide that data later at the end of this month and testify.
That'd be terrific. We've heard a great deal about kids needing high tech, high level services. So this will be informative. No, that's all I have. Thank you, Madam Chair. And thank you,
Thank you.
Commissioner.
Cheryl?
Thank you, thank you. Commissioner, you mentioned that it's hard to find beds, and I'm looking at the numbers, and I know that they're fluid and they're constantly changing. Is there a waiting list? What do you do with people if the beds are maxed out? You know, what happens to those individuals? And are these beds maxed out?
There are times when certain programs where a youth could use that program are full, and we evaluate, the youth that are there. And many times there's a youth ready to transition out in a week or a couple of days. That's been, their discharge planning has been in place, and that's been their goal. We work to keep that youth wrapped with services in the community, in a community setting. Depending on the circumstances, and until we can put that youth in another type of that facility once that opening happens. If there's not one long term, that's when we start shifting to see what are the other options to meet that needs. Is there another in-state program that we might be able to tailor something to, or do we need to start looking out of state?
So I'm looking at especially the in-state individuals, and recalling that during the session, there was a time when some of these were being monitored by state employees. And I'm just curious to know if that's still going on.
Yeah, it has happened. To be transparent with you, just as an example, on Friday, we had a youth who was asked to leave a program on the chin side due to behavior. And we evaluated the youth needs, and there was another program that was going to be available on Monday as a part of our work to serve higher end youth with needs. We had utilized, we have a location in the northern part of the state and a location in the southern part where we have access to apartments or houses, where we can then staff that youth until the opening happens. Unfortunately, our child protection system isn't a 9-to-5 business, and sometimes things happen outside of business hours you have to react to. And in this case, it happened at the end of a work week on a Friday afternoon. And so we responded and successfully served that youth over the weekend, and staffed it with staff who have received training now, and then also provided some law enforcement coverage just to ensure that if something happened, we were able to respond quickly. But then we were able to place that youth first thing this week. And so it doesn't happen often, but when it does, we are prepared to support those youth.
Okay, thank you.
Any other questions, comments? Okay. Thank you.
Thank you.
Sure. Okay, so let's shift gears to the hope this afternoon was we do have a committee charge on expungement to recommend legislation that addresses certain areas of expungement, like what crimes would qualify. Due to Michelle's situation and not being able, Michelle Childs, and not being able to be here, we've got to really put that off to next meeting. But we did have some folks from our meeting last week or last month, that we just didn't have time to schedule in, and we were hoping to have them scheduled this afternoon. And are they going to Zoom in? Do you know, Julie? Have you heard anything?
Michelle is on.
Michelle is?
Yes. Is she on your iPad?
Oh, okay, Michelle Pelletier.
Yes.
Okay.
Oh, I'm sorry.
I was thinking, I wasn't looking, I was looking on the screen. So let's start with Michelle. I know this was testimony. You were great last month. We just didn't have enough time to fill for everyone that was to testify on the expungement issue. And so thank you for being willing to be rescheduled to this month. So Michelle, welcome. And if you could just identify yourself for the record.
Yes, my name is Michelle Pelletier. I am the Restitution Unit Manager, and I'm here today on behalf of the Vermont Center for Crime Victim Services.
So do you have testimony you wanted to submit or testify to in terms of expungement, the current?
Yes, I do.
Okay. So it's all yours.
Okay, perfect. So by statute, the Vermont Center for Crime Victim Services is charged with promoting the rights and needs of crime victims statewide. The center has actively been engaged in the statewide criminal justice reform conversations. The center understands the barriers that criminal records can have on basic needs such as housing and employment, and appreciate the positive impact in sealing and expunging records can have on the lives of criminal defendants. However, I would like to outline a few concerns that we do have regarding S7, as it could possibly impact restitution, the victims' compensation, and crime victims and survivors. So the Restitution Unit is, again, a department within the Center for Crime Victim Services. We're charged with collecting, dispersing, and enforcing restitution judgment orders on behalf of crime victims in Vermont. We also help them access the Restitution Special Fund when eligible. Restitution not only plays an important role for victims, but it also aids the criminal defendant's own rehabilitation. Many criminal defendants take pride in repairing the financial harm they have done. Records should only be sealed or expunged after the restitution order is fully satisfied. The opportunity for sealing and expunging records is a major incentive for criminal defendants to pay the restitution in full. If sealing or expungement is granted, despite an offender's failure to pay restitution in full, the victim or their state is left with nothing to pursue. In addition, in essence, victims of offenders whose records are sealed or expunged are not afforded the same rights to restitution as victims of offenders whose cases have not been sealed or expunged. The Victims' Compensation Program is also part of the Center for Crime Victim Services. They're responsible for paying eligible crime-related losses to victims who have experienced an uninsured financial loss as a direct result of a crime. A victim is required to submit a victim's comp application to the program and shall be eligible if compensation, if a law enforcement official has filed a report concluding that a crime was committed. When a crime occurs involving a victim, a compensation program has the eligible application on file to include documentation from law enforcement. The victim remains eligible for compensation benefits even if the case is expunged or sealed. However, if the victim applies to the compensation program after the case is expunged or sealed, the victim would not be found eligible for the Victims' Compensation Program. The program would not be able to obtain the law enforcement report necessary to prove probable cause. Therefore, those records should be available to the program so the victim can be compensated. As with restitution, victims offenders with expunged or sealed records are not afforded the same right to compensation benefits and services as victims of offenders whose cases are not expunged or sealed. Expungement and sealing of records can be very traumatic to victims. The record of a crime is destroyed and no longer exists for the offender, but that's very real for the victims involved. Crime victims in Vermont are given the fundamental right to the notification to offer a statement in the sealing expungement process. Crime victims have important perspectives and can address relevant factors. Any change to sealing or expungement procedure should not impact the victim's right to notification and be heard. We must not ignore or lose sight of the crime victims when we discuss criminal justice reform. Thank you.
Questions? Maxine?
Yeah, I'm just wondering if you haven't already, submit your testimony to us, please.
Okay, and I'm sorry, this is my first time. How should I do that? Can I just do it to Jill?
It would be to Julie Tucker.
Oh, I'm sorry. That's what I meant. I'm reading her name wrong. Julie Tucker, yes.
Yes, and then she can post that onto our webpage.
Okay, perfect. I will get that sent out in just a few moments.
Okay. Are there any questions? I mean, I think you had
I
some.
don't know if it's a
good
question.
Dick?
I don't know if it's a question or comment. I don't remember anything in either version of S7 that would have not required full restitution. The issue became surcharges.
Right.
And I know the surcharges do help fund various programs, but many people chalk up numerous surcharges with like 5 charges, and getting them expunged and paying off the surcharges are often extremely difficult. And I believe that was the area that S7, at least as it passed the Senate, would have allowed the court to not require the surcharges. But I think all bills that we've ever done on expungement have recognized the importance of restitution, both to the victims and to the offender. I know I heard your statement and I want to recognize that.
Okay, thank you. And I know Chris Fenno, our previous director, has testified regarding restitution prior. So yes.
Other comments, questions? Okay. Thank you.
Great. Thank you so much for your time today. Have a good afternoon.
Yes, thank you for being willing to reschedule.
Yes, no problem.
And next was also from Legal Aid, Marid O'Reilly. Thank you again for rescheduling. I know we had a long meeting a month ago. So if you could just identify yourself for the record and begin your testimony would be great. Thank you.
Sure. Marid O'Reilly from Vermont Legal Aid. Good afternoon, committee members, and thank you for allowing me to speak and testify at this follow-up hearing on S7. I, like many of the previous witnesses, am always happy to talk about collateral consequences and expungement, and am also disappointed that we're back here discussing a piece of legislation that in 2019 was unanimously approved by the Sentencing Commission, and then which passed the Senate in 2020 and passed again this past year unanimously. So coming back to this, is, as I said, a little disappointing because there are so many other issues that you and Legal Aid need to focus on. But we're ready. We really want to help get a good bill out this year and are here to provide any assistance that you may need. We have come back, Legal Aid's come back every year since 2018 to work on the expansion because low-income Vermonters who have served their sentences need legitimate and robust relief from collateral consequences of criminal records that prevent them from being fully reintegrated into our communities. Hundreds, I would venture to guess thousands of Vermonters have been eagerly awaiting this relief, including people like my client, Michelle. Michelle testified before the Senate Judiciary Committee in 2020 in Winooski during a huge snowstorm. She drove up from the Bennington area just before the pandemic. And for those who weren't in attendance, Michelle is 57. She has a felony possession of stolen property conviction from Bennington and from 1989. The crime and the circumstances surrounding this crime were tragic. I won't get into it, but there was a family death and this possession of stolen property related to her younger brother. She doesn't quite remember whether she was, whether she was in such a state of grief that she doesn't quite remember the situation surrounding the crime, but she has lived with that felony on her record for over 30 years. She has raised many children and has been stuck in low-paying jobs, making no more than $40-something thousand each year. She says this has been barely enough to pay for her mobile home and her, feeding her children and taking care of their basic needs. Michelle, I hope you'll meet her later this session or during the actual legislative session. Michelle is brilliant and articulate, and she is an amazing helping worker. She's wanted to do nothing more than go into the mental health field so she can help people who, like herself and her siblings, experience profound childhood trauma. And instead, she's been stuck in a low-paying paraprofessional job, certainly making an impact, but not making enough to become independent of state benefits. When I spoke with Michelle last month to tell her the news about S7, she was incredibly disappointed. And she said she really wants Vermont lawmakers and advocates and policymakers to know that now is the time, she said, now more than ever, it's the time to pass this or a similar law because there are so many jobs we need to fill and we need to let these capable people fill them. She said, we just can't do this with our records. The scope of the problem is large, as you all know. 1 in 3 Americans have a criminal record, and there's no indication that Vermont is exceptional in this regard. The consequences are immediate. Folks with records struggle to get decent employment. Wages are far lower with people who have criminal records. And we know that the impacts of a criminal record are intergenerational. So children of parents who have records have diminished earning potential as adults. Collateral consequences impact even people with lower level misdemeanors. And this disproportionately harms BIPOC and people with disabilities. We know that excluding people from the economy harms public safety because people who can't work legally find other ways to provide for themselves. Vermont, like all states, has significant restorative work to do for our communities that have been over-policed and over-incarcerated and oversaddled with criminal records. Legal Aid's perspective is that we need to continue to be courageous and zealous in both admitting the harm that's been caused and addressing it head on. I feel optimistic that this legislature can and will pass a robust second chance reform this coming session, and that this S7 will be a big part of that. Vermont, I can talk a little bit about the sort of relief that we would hope S7 or the successor, the next bill coming from S7 to include. But generally, we thought that S7 was a really great model. We would want to see a bill that significantly expands the access of expungement and sealing, making it available for most offenses. We would like to see that the default really be at some point, all or most offenses are eligible for sealing or expungement, with a very careful selection of the crimes that are accepted from that default. We also think that Vermont can and should think about creating a more streamlined or presumptive expungement process for some types of crimes, as is already done in the diversion and deferred sentence context. And like the growing number of states who are implementing clean slate laws, in recognition that this helps with low uptake rates that are endemic to these second chance reforms. Also, in our context, that could be one of the answers to the stated state's attorney concerns surrounding their limited resources. So to have a more streamlined or presumptive expungement for a subset of crimes could get at that resource issue. Our position is that wait times for expungement should be as narrowly tailored as possible, because we know that every year that Vermonters are excluded from the formal economy, we are losing out on their invaluable human potential, and our communities are also robbed of their economic contributions. The states, I think we all recognize that when folks can't sustain themselves and their families, they turn to the state. And so the state is ultimately providing more financial support for folks who have criminal records, most of whom really do want to be totally independent of public assistance. Regarding the one-track simplification, the Attorney General's office was optimistic that there is likely a compromise to be reached on that. And we agree. And we also echo the Defender General's primary concern, that if we are to move to a one-track sealing system, that access must be limited, and that, frontline law enforcement folks should not be able to use these records to inform their stops or their investigations. Senator Baruth mentioned in July, when this committee took up S7, that there should be a mechanism to hold violators to account if we were to move to a sealing only system. We think that's a great suggestion and one we would support. We also believe that maintaining the individual discretion of the state's attorneys is crucial. State's attorneys are elected officials. They're stewards of community safety in their own individual jurisdiction. And if they deem that it's safe to clear a record early, then they should be able to do so. And that's as in the weeds as I think you probably want or need right now. But I thank you for your ongoing commitment to this issue and welcome the opportunity to assist in any way, whatever would be most helpful to your deliberations going forward. So thank you.
Great, thank you. Thank you. Questions, comments? Thank you, Merit. Is that how you pronounce your first name? Merit? Merit?
It's Marade. It rhymes with parade.
Marie. Marie. Okay. Thank you. Thank you for taking the time today. So I don't know what conversation maybe Dick and Maxine want to have about expungement. I know that we do have to, as the committee makes recommendations. I was hoping the plan was that Michelle would go over a committee charge. We would talk about new legislation that maybe we would want to introduce. I don't know where Dick and Maxine want to go with this. I think also we need to wait for Michelle for next month as well, but you folks have maybe doing some work with David Shear. In the AG's office.
Yes, continuing to work on it. Yeah, so but I think it can wait. Yeah.
I think it would be helpful if Madrid would give us a copy of her testimony as well. It was well done, and I would like to, if you can do that.
Julie, would you be willing to talk about with her? Cheryl? Do you want to weigh in, Cheryl?
I just wanted a clarification of what is eligible for expungement. And I think I'm getting differing opinions. I have a constituent who, like Michelle's, like Mairead's constituent, Michelle, committed a crime over 30 years ago. She was 27. I've been told that, she was too old at the time of the crime because this only applies to people who have committed a crime prior to being 25. So I'd like clarification on that. And are we looking, and maybe we would look at expungement based on crime rather than age. So that's, my concern right now. I'm a little confused as to why my constituent isn't eligible for expungement.
Does that make sense to either one of you folks, Dick or Maxine, that age was determining?
The age was a compromise, as I remember, and I don't remember a compromise. We'll look at those under 25 somewhat differently for several serious crimes. And so I can't really, my recollection right now, I'm sure Michelle or Bryn would have that information. But that was a compromise made, and I can't remember if it was a compromise in the Senate, a compromise with the House, or the House and the Senate, or what, but I remember that. And we took the 25 because that's basically when we're talking about raise the age and the level of when your brain develops, etc.
And that, makes some sense, but we're talking about people who, 30 some odd years ago
were involved in a crime and may or may not have been, certainly if it's a violent crime, it's one thing, but if it's a crime of, in this case, it was shoplifting.
And, when I think Maxine would have a better recollection of what happened this year with S7, because when it had passed the Senate is when the governor's office got involved and made changes. And I'm not sure whether your constituents' crime would have been covered by S7 or does it pass the Senate? That's the other question. And it got
There's a lot of layers to this. Why don't you follow up with Cheryl? Because I think, Cheryl, your issue is when your constituent was 27, she was charged and convicted of a crime. And now she's trying to get an expungement for that. And the reason why they're saying to her that she would not qualify because she was 27 years old at the time of the crime. And she would have had to have been 25 years old or younger in order for that to qualify for an expungement. Is that what you're asking?
That's what I'm asking. Yeah.
I don't know. Maybe Maxine can follow up with you on that.
Senator Hooker, I could also follow up with you on that. I think part of what Senator Sears was getting at is that S7 would have actually included like a felony retail theft, or in my client's case, a felony possession of stolen property. Those would become eligible under the expungement law. I think your client, your constituent has been told she's not eligible under the juvenile sealing law, which right now is one of the only mechanisms to clear most felonies from her record. So, but if S7, as it was drafted and passed the Senate unanimously, were to pass again, a felony retail theft would become eligible for expungement.
Okay, thank you, Mary.
You're welcome.
That clarifies it. Jenny?
Yeah, so I think if we're going to pursue any recommendations around S7, it would be extremely helpful to have Michelle or someone else just go through the process the bill went through and the changes that were made along the way. And then the recommendation that Senator Baruth made in July is something that probably would come out from the judiciary, because most of us were not directly engaged in writing that bill, yet we have a strong interest in it, and now more so than ever. So just having a run through of what happened, where the bill is now, and the implications based on the testimony that we've heard would be extremely helpful.
So in our charge for this expungement, which is a result of the issues revolving around S7, is that we would need to consider how to simplify and automate the process of expungement and sealing of criminal history records. And then the committee, meaning our committee, would offer possible legislation with recommendations regarding, and we have 4 items that we would need to address. One is a policy to make all or most criminal history records eligible for sealing or expungement, except for conviction records of offenses listed in 33 BSA 5204A. I'm assuming those are the listed crimes. But individuals or entities would have access to those sealed records. Whether Vermont should continue to employ a two-track system that provides for sealing or expungement based on the nature of the offense, and whether or not to implement an automated process, which means not requiring a petition to seal and expunge criminal conviction records that provide for notice to the prosecuting office and an opportunity for the prosecutor to oppose the sealing or expungement. That's our committee charge around expungements. So the thinking was to put that on the agenda today was to start addressing some of those items so that we could see what possible legislation might be introduced. Because of the situation with Michelle Childs, the bulk of this will pick this up in the September meeting. And I know there's also work happening with the Attorney General's office on this as well. Does that relay pretty much, Dick and Maxine, what's occurring?
Yeah, I just would say, if we go to a ceiling rather than expungement, full expungement, which I don't really have a problem with, the issue will be who gets access to those records that are sealed. And that's going to be controversial because I believe law enforcement believes they should have access to sealed records, which they wouldn't have to expunge records. And many of us, I'll put myself in the spot, believe that that should only be accessed by the individuals whose record was expunged. If for some reason they needed it, I understand there's some immigration issues that or access for research purposes, which wouldn't identify the individual. So that's going to be the real hot contested issue there. Which crimes, I think, comes down to what how you feel about certain crimes. I think the governor's office was concerned about certain crimes and enumerated some of that. And automated has some advantages, but also has some disadvantages that local prosecutors and others wouldn't have, and victims might not have an opportunity to speak up. But those are really the issues.
So we'll schedule the more in-depth work on this for September. And I think the first thing with Michelle Childs is to really have her go through the process of expungement so that we can understand it, because we're not all on the Judiciary Committee. It's not our forte. And then figuring out where we go from there for that. Do you think you'd be able to have more information from the Attorney General's office by September?
I hope so.
Okay. You hope.
I can't speak for them, but this is certainly a priority for the Attorney General's office and others and myself. So definitely want to move forward on it.
Okay. So our agenda is done for today. I wanted to have time for the committee discussion. And next month for our agenda, I know DOC was scheduled originally for today, but some folks are on vacation this week. Some folks had some family issues, so it wasn't going to work out well. So we're going to reschedule them to September. It's really to give an update on the process of replacing the women's correctional facility, where we are, just to check in on that. And I know that some folks from BGS and DOC took a trip over to the main facility, the women's reentry facility over there. And they may have some discussions on what they saw there. So that's in September. On top of the expungement issue, are there other issues that folks are interested in? Butch?
Well, one of our charges is to get a progress report from DOC on their body camera policy, and it's supposed to be to us by the 15th of September. We're meeting the 14th. Now, it might be with all your group here. Would it be convenient to do that at the same time?
We could try. Do you think, Rachel, it would be done in time for the 14th?
With all due respect, I certainly hope so, since it's on the 15th.
Right, or even a.
I get that.
It's the body cameras.
Yeah.
Right?
It's just a report to us where how you're doing. So save you a trip.
Would it be possible to hear from the Secretary's office or the Office of Human Resources. I mean, this issue of staffing keeps coming up. It came up at our last meeting regarding staffing prisons. It came up with this and not having enough beds and programs. The worry that if you pay more at Beckett, they're going to be taking employees from other programs that will then have problems. I think I'm also running into other human service areas where I know my local designated agency, and Representative Wood brought this up, and I thought it was well spoken, because my local designated agency is down 4 clinicians, and some of it's due to the Beckett program in Bennington taking clinicians because they're able to pay more. So I think it's a problem in terms of both the corrections and other areas. I don't know if anybody has a plan.
So does Agency of Human Services have an HR person, or is that a state HR person for all the employees?
It's not employed by the Agency of Human Services, but they have a human resources officer assigned to, probably more than one, assigned to HS. Yeah.
So is that who you're thinking, having the?
I'm thinking that at least the secretary's office level, because this is an agency-wide problem. Not just corrections, as we heard last week, but now this week we heard about the same problem.
It's throughout, and it covers our designated agencies and our specialized service agencies, because those agencies can't pay the big dollars that others can. And so you have a young workforce with high turnover rates and low income. The result is that we're constantly shorthanded. And so this is not new to those of us who have been working in our healthcare and human services committees, but it would be very helpful to look at who's coming into DOC, what the turnover rate is, where folks are coming from and where they're going to. What kind of substance use disorder services? I mean, because this could go on like Topsy, go through the Department of Health and everything else. But if we could focus in on what's going on at DOC, I think that would be extremely helpful.
But Jenny, you're correct that it's been going on for a long time, but it's been exasperated, I believe.
It has been exasperated by COVID, and which is why we put so much time and our programming and funding into improvements in this area. So we have scholarships, and we've raised the rate of pay for our DAs and our SSAs recently, as well as our long-term care folks. It's a long-term, long-range problem, but it's not that we're not working on it. And I know you've worked on it in appropriations as much as we have in health and welfare. So I don't know whether you want to pick up the whole broad area or focus in one area. And maybe.
Well, I'd just like to know if the Agency of Human Services has a plan or not.
That's a good idea.
Have what? A plan?
Yeah.
Okay.
Maybe that's probably an excellent idea. Are they waiting for us, or are they doing something?
Well, H-153 is sitting in the Senate.
So I think this goes way beyond.
Don't worry.
Can go. You done?
I'm sorry, that was one of those under the breath comments that.
Yeah, okay.
Yeah.
It sure was.
Exactly. We'll have to be careful when the session starts.
Yeah. So I agree, Dick, that this is it's a huge problem in human services, but it also transfers to everywhere in state government. And I'm looking at our chart. We're supposed to look at transporting prisoners, and we're supposed to make sure timeliness and judicial procedures are being followed. And I read the other day they're closing down a courthouse in Grand Isle County because they can't get security from the deputy sheriffs. And now they want us to look at who's transporting who. And if it's deputy sheriffs, are they, I don't know the better way to say it, picking the best option for them and not providing services throughout their contracted services to the state. So starting in human services with the HR person there is a great start, but I think we may need to listen to others, find out what the picture is for the entire state. And I doubt that we're recruiting in a coordinated manner. I think it's probably more like a shark that would help. So it's an interesting conversation to have, and starting with human services is a good spot, I guess.
It's the one that we really look at the most
Yeah.
when we're talking about DOC, and now we've heard about DCF. It's more so. So I've put that down. The other thing in looking at our charge, and this may be too soon, the middle of September, on or before October 1st, the Sentencing Commission was to give us some recommendations on whether or not probation terms for misdemeanor offenses are held to 2 years. I don't know where the Sentencing Commission, if they'd be able to do anything for September, but we wait till October for this. Any thoughts? We could do it in October. It says on or before October 1st.
On the Sentencing Commission, and I believe that the Sentencing Commission can probably report out on that already.
In the middle of September.
I can't speak for Judge Zoe, the chair of the Sentencing Commission. I just know that the Sentencing Commission has already discussed and reached a consensus on this. So I can probably handle pretty promptly.
Okay.
I'm not sure if he intends to turn it into some sort of report or just his testimony, but it's commission's already discussed.
Okay. So we'll check, and if they're ready, it would be good to get that off our plate. Just want to make sure.
Sentencing
You know,
Commission is meeting Friday, October 22nd. I've got an invitation to that.
But you're saying, Marshall, that they've already addressed this piece prior to October? Okay,
It was addressed at the last meeting, which I think was at the last one.
okay. So we'll check with the chair of that and see. Okay, then we can mark that off our list.
So,
Um,
Representative Emmons, Madam Chair. I did send you an email earlier today about a study that's going on UVM, by UVM on custody issues that I think would be extremely informative for both of our committees in November. So that's when the study will be complete and recommendations made. So, I mean, look at that. Look at the information I sent you, and then I copied Senator Sears and Representative Pugh on this, because they're also on child protection. And then we can talk about whether you want to present that option to the committee to meet jointly.
So that would be more for November?
I think so, yeah, because that's when the study would be complete and analysis done and recommendations made. So we could then have something to carry forward into our legislative session.
So it looks like we have a pretty full agenda for next month. And I will work with Peggy Delaney to set this up. I believe it would be Peggy, now you two, right? And then hopefully Michelle will be in a better place than she is right now. We have not scheduled anything for October, an October meeting. Do folks want us to send out a doodle poll for that, or do you want to try to work something right now while we're here? for October.
I probably won't be here in October.
No,
No.
you're having a second one.
I'm not doing anything, but yes.
When are you due?
The 23rd.
Never go.
Oh, it's a Saturday, we're okay.
Yeah. I'm just not making any plans in October for anything. I'm just leaving it wide open.
Good choice. Do people want to just respond to a doodle poll?
Sure.
Maybe we can do October and November. Oh, God, can October and November? Yikes. Thanks. So anything else for today? I would think in September, we're probably still meeting in person. I mean, it's just kind of a day by day, wait and see what's happening with the variant. I'm just thinking everything's pretty fluid. So anything else before we finish up and adjourn, and you folks can go back and you're at home, stay put, stay cool. Anything else? Okay.